All rise. Vous vous levez. L'International Criminal Court is now in session. L'audience de la Cour pénale internationale est ouverte. Please be seated. Veuillez vous asseoir.
Good morning, everybody. Court officer, please call the case.
Thank you, Mr. President. Your Honors, the situation in the Democratic Republic of the Congo in the case of the prosecutor versus Bosco Ntaganda. Case reference ICC 0104-0206. For the record, we are in open session.
Thank you, court officer. First of all, I would like to welcome back the parties, the participants, and Mr. Ntaganda, the accused. And I also welcome those who are watching this hearing from the public gallery and via the internet. Before we go into purpose of this hearing, please state the appearances for the record and the public, starting with prosecution, please.
Good morning, Mr. President. Good morning, Your Honors. For the prosecution today are Ms. Julieta Solano, Ms. Marion Rabani, Mr. Renz Vanderwerf, Ms. Salam Yurgu, and myself, Nicole Sampson.
Thank you, Ms. Sampson. Defense, please.
Bonjour, Monsieur le Président. Bonjour, honorable juge. Représentant Bosco Ntaganda, qui est présent dans la salle d'audience ce matin, Madame Océane Mlanao, Madame Clémence Vol-Marvaldi, Madame Amanda Martinez, Madame Margot Portier, Maître Mélissa Beaulieu-Lucier, Maître Christopher Gosnell et moi-même, Stéphane Bourgon. Merci, Monsieur le Président.
Merci beaucoup, Monsieur Bourgon. Now, legal representatives for victims, please.
Merci, Monsieur le Président. Les anciens enfants soldats sont représentés par Alejandro Kiss, Anna Bonini et moi-même, Sarah Pellet, conseil au bureau du Conseil public pour les victimes.
Good morning, Mr. President. Good morning, Your Honors. For the victims of the attacks, Anne Grabowski.
Thank you, Ms. Pellet. Thank you, Ms. Grabowski. And registry?
Good morning, Mr. President. Good morning, Your Honours. May I introduce Bibiana Becerra and myself, Peter Lewis, on behalf of the registry.
Thank you, Mr. Lewis. To make appearance complete, the chamber is composed of Judge Kuniko Ozaki on my right, Judge Chango Chung on my left, and myself, Judge Robert Fremer. The chamber is today assisted by legal officers. From the left, legal intern Ms. Diniach Mason, then our visiting professional Ms. Barbara Hola, then legal officer Nicole Fitzsimmons, legal officer Mr. Rohir Bartels, and legal officer Ms. Raluca Rakasan, just on the right. Today, the chamber is going to render its sentencing judgment pursuant to Article 76 of the Rome Statute in the case of the prosecutor versus Bosco Ntaganda. The sentencing judgment is 117 pages and has one annex. I will now read out just a summary of the sentencing judgment, which is meant to convey those findings that we considered most relevant to the accused and the public, and the sentence determined by the chamber. The full written sentencing judgment will be made available as soon as this hearing has concluded, and it's a fully public document. I will start with a brief procedural overview. On 8 July 2019, the Chamber convicted Mr. Bosco Ntaganda of various crimes against humanity and war crimes. This case concerns the conduct of Mr. Ntaganda as a member of the Union des Patriotes Congolais, which I will refer to as the UPC, and its military wing, the Force Patriotique pour la Libération du Congo, which I will refer to as the FPLC, in relation to events that took place in the Ituri district of the Democratic Republic of Congo in 2002 and 2003. On or about 20th November 2002, the UPC FPLC launched an assault on Mongwalu, which is in the Banyale Kilo collectivité. After it took over Mongwalu, the UPC FPLC also captured Sayo, Kilo, and Zebe. In February 2003, the UPC FPLC launched a coordinated series of assaults on several villages in the Valendu Diatse collectivité and took control over the villages of Lipri, Tsili, Kobu, Bambu, Buli, Gola, Yichu, and Nyangarai, as well as some surrounding places. The majority of the crimes that Mr. Ntaganda was convicted of were committed during these two operations. In addition, Mr. Ntaganda was convicted for the conscription and enlistment of children under the age of 15 and their active use in hostilities, as well as for the rape and sexual slavery of some of these children. The Chamber convicted Mr. Ntaganda as a direct perpetrator pursuant to Article 25, sub 3a of the statute for one murder as a crime against humanity and as a war crime, and for persecution as a crime against humanity. He was convicted as an indirect co-perpetrator pursuant to the same provision for the other murders and acts of persecution, as well as for all of the other crimes. On the same day as it delivered the judgment, the Chamber ordered the prosecution, the defense, and the legal representatives of victims to file any requests to submit further evidence or to call witnesses in relation to sentencing by 29 July 2019. Following requests from the parties, the Chamber authorized 3 witnesses to testify before the Chamber in person and admitted into evidence the prior recorded testimony of 5 more witnesses, as well as several documents and videos. On 17, 18, and 20 September 2019, the Chamber held a public hearing on sentencing, during which it heard the aforementioned 3 witnesses and oral submissions of the parties and the legal representatives of victims on the sentences to be pronounced. On 30 September 2019, the parties and legal representatives filed their written submissions on the sentencing and responded to each other on 8 October 2019. I will now briefly set out the legal framework that the Chamber has applied for this judgment. The Court's statutory framework established a comprehensive scheme for the determination of a sentence. Also, Articles 77 and 78 of the statute do not specify the purpose of punishment for crimes under the statute. The preamble establishes retribution and deterrence as the primary objectives of punishment at the court. Retribution must not to be understood as fulfilling a desire for revenge, however. It rather is an expression of the international community's condemnation of the crimes. By imposing a proportionate sentence, the harm caused to the victims is also acknowledged. A sentence should further be adequate to discourage reoffending and to deter those who may consider committing similar crimes from doing so. The court's legal framework does not contain mandatory minimum or maximum sentences or sentence ranges for specific crimes. Article 78, para 3 does, however, provide that any joint sentence of imprisonment may not exceed 30 years unless the extreme gravity of the crime and the individual circumstances of the convicted person warrant a term of life imprisonment. The Chamber enjoys broad discretion in determining the sentence, but the totality of the sentence must be proportionate and reflect the culpability of the convicted person. Basing itself primarily on its findings in the judgment, the Chamber considered the gravity of the crimes first generally in abstracto by assessing the constitutive elements of each crime in general terms, and then in concreto by assessing the particular circumstances of the case, looking at the degree of harm caused by each crime and the Mr. Ntaganda's culpability in relation to thereto. The sentence must also reflect the individual circumstances of the convicted person, including an aggravating and mitigating factors. In the case of aggravating factors, the Chamber did not rely on the same factor more than once, and any factors it assessed in relation to the gravity of the crimes were not considered as aggravating circumstances and vice versa. I will now turn to the main findings on the crimes Mr. Ntaganda was convicted of. I will start with our findings on his culpability. At the outset, the Chamber recalls that Mr. Ntaganda was found guilty as an indirect co-perpetrator for the crimes charged with the first and second operation. Those crimes were charged under counts 1 to 5, 7 to 8, 10 to 13, and 17 to 18. With the exception of sexual slavery as charged under counts 7 and 8, and attacking a protected object under count 17, these crimes were committed during both the first operation and the second one. The Chambers found that Mr. Ntaganda and his fellow indirect co-perpetrators agreed to drive out the Lendu from the attacked localities. They therefore meant for civilians to be attacked and killed, for their property to be appropriated and destroyed, for civilians to be raped and subjected to sexual slavery, for civilians to be forcibly displaced, for protected objects to be intentionally attacked, and for the aforementioned conduct to be targeted towards the Lendu civilian population as such, which thereby amounted to persecution. While Mr. Ntaganda's degree of participation in the first and second operation varied, as I will explain later, his degree of intent in relation to the crimes committed during both operations was the same. As far as Mr. Ntaganda's degree of participation in the crimes committed during the first operation and the second operation is concerned, the Chamber considered his participation as part of its assessment of the in concreto gravity of his culpable conduct. In this respect, the Chamber recalls that it found in the judgment that the first and second operation were part of one and the same plan to drive out all the Lendu from the localities targeted during the course of the UPC FPLC military campaign against the RCD-KML. The UPC FPLC soldiers' acts during these two successive operations formed part of the same course of conduct. As a tool in the hands of the co-perpetrators, the conduct of the individual UPC FPLC soldiers in the execution of the crimes was attributed to the co-perpetrators as their own. The Chamber further recalls that Mr. Ntaganda gave orders to commit crimes and personally engaged in violent conduct towards the enemy. The Chamber only found this in relation to the first operation, but this was just one of the ways through which Mr. Ntaganda contributed to the common plan. The Chamber considered his culpability for the crimes committed during both the first operation and the second operation to be high, irrespective of whether he was in close physical proximity to the locations where the crimes were physically committed, and also in instances where he did not have previous contemporaneous or subsequent knowledge of the specifics of the crimes committed. Mr. Ntaganda's culpability in relation to crimes found to have been committed during the second operation is therefore not less or diminished as compared to his general culpability for the crimes that were committed during the first operation. Rather, the fact that during the first operation he gave orders to commit crimes and personally engaged in violent conduct towards the enemy, as set out in the judgment, is a factor which, in the view of the Chamber, further increases his culpability. The defense argued that all of Mr. Ntaganda's contributions to the second operation were directed towards a lawful military purpose of the second operation. However, the Chamber recalls that the first and second operation were part of the same military campaign and constituted a logical succession of events. The success of the UPC-FPLC assault on Mongwalu, which was coordinated by Mr. Ntaganda, allowed it to continue with the commission of crimes against the targeted groups during both operations. Now I will first discuss the crimes against life that Mr. Ntaganda was convicted of. As regards murder as a crime against humanity and as a war crime, Mr. Ntaganda was found to be responsible as a direct perpetrator for the murder of Abe Bwanalonga in Mongwalu during the first operation. The Chamber also found Mr. Ntaganda responsible as an indirect co-perpetrator for murders committed by UPC-FPLC soldiers and in one location also by Hema civilians during the course of the first and second operation. In determining the appropriate sentence, the Chamber took into account the fact that the same conduct underlies Mr. Ntaganda's convictions for both murder as a crime against humanity, charged under count 1, and murder as a war crime, which is charged under count 2. Murder is inherently one of the most serious crimes. The Chamber convicted Mr. Ntaganda of the murder of at least 74 individuals and the attempted murder of 5 more, in addition to making broader findings of murders of unquantified numbers of persons. This means that murder was committed on a large scale. As to the harm caused by these murders, the Chamber received evidence from a witness who knew Abe Bwanalonga personally. This person indicated that Abe's death became notorious among the clergy and the population. To this day, the 3 nuns who were abducted together with Abe refused to speak about what they witnessed. In addition to the direct victims, the murders irreversibly impacted also those who witnessed them, the victims' family members, and other relatives left behind. Some individuals who survived or witnessed the murders and attempted murders still bear permanent scars, both physical and psychological, including long-term memory loss, neurological disturbances, and extensive physical scarring. Mr. Ntaganda's degree of culpability is substantial in relation to the murders and attempted murders committed during both operations, and his degree of participation was even higher during the first operation due to his proximity to and intensity of his involvement in the murders committed during this operation. The Chamber further identified the following factors in aggravation: the particular cruelty of a number of incidents, the particular defenselessness of some of the victims, and in relation to the murder of Abe Boniface Bovanalongwa, the fact that Mr. Ntaganda, as a high-ranking official, committed the murder in the presence of his subordinates. As regards the Abe's murder, the Chamber also considered Mr. Ntaganda's discriminatory intent. The Chamber further found Mr. Ntaganda responsible as an indirect co-perpetrator for intentionally directing attacks against civilians in Mongwalu and Tsayo in the context of the first operation, and in Bambu, Yichu, and Buli in the context of the second operation. The crime of intentional attacking civilians is a serious violation of one of the fundamental principles of international humanitarian law. And it's as a crime which does not require an actual harm to occur for the elements of the crime to be established. The Chamber considered it to be less serious than those crimes against life that require the actual occurrence of that harm, such as murder. Civilians were intentionally attacked in 5 locations during both the first and the second operation. The crime was therefore committed on a relatively large scale. The Chamber considered Mr. Ntaganda's degree of culpability to have been substantial in relation to the aforementioned attacks. Part of the attacks took place during the assaults in Mongwalu and Tsayo, which were overseen by Mr. Ntaganda, and on one occasion, Mr. Ntaganda directly ordered a soldier to fire at a group of fleeing persons. The Chamber therefore considered his degree of participation during the first operation to be even higher. While the crime of intentionally attacking civilians is committed by the mere launching of an attack, the Chamber identified that in some instances, as a result of the attacks launched, civilians were in fact killed or injured. This was treated as an aggravating circumstance. I now turn to sexual violence crimes. The Chamber found Mr. Ntaganda responsible for sexual violence crimes committed against 2 distinct types of victims, namely members of the civilian population. This was charged under counts 4, 5, 7, and 8. And second, against female UPC FPLC members under the age of 15. This was charged under counts 6 and 9. Noting the different factual considerations relevant to the 2 types of victims, the Chamber analyzed the 2 types of victims separately and pronounces a separate sentence for rape and sexual slavery as war crimes for the civilian victims and for the UPC FPLC victims. In relation to the crimes committed against members of the civilian population, the Chamber found Mr. Ntaganda responsible as an indirect co-perpetrator for rapes by UPC FPLC soldiers of women, girls, and men during and in the aftermath of the UPC FPLC assaults on Mongwalu and in Kilo in the context of the first operation, and in Kobu, Sanji, and in Buli in the context of the second operation. The overall number of specific rape victims was 21, but the Chamber also made broader findings on rapes of unquantified numbers of persons. In addition, the Chamber found Mr. Ntaganda responsible as an indirect co-perpetrator for the sexual slavery of a woman and of an 11-year-old girl in the context of the second operation. In relation to the crimes committed against female UPC FPLC members under the age of 15, the Chamber found Mr. Ntaganda responsible as an indirect co-perpetrator for the rape of an approximately 9-year-old girl and the rape and sexual slavery of 2 girls under 15 years of age. For the purpose of its analysis, the Chamber took into account the fact that for the sexual violence crimes committed against members of the civilian population, the same conduct underlies Mr. Ntaganda's convictions for both rape as a crime against humanity and rape as a war crime. This is also the case for the convictions for sexual slavery as crime against humanity and sexual slavery as a war crime. The Chamber also took into account that its findings in the judgment on the second legal element of sexual slavery, namely that the victims were made to engage in one or more acts of sexual nature, were based on the rapes committed against them. This part of the conduct underlying the convictions for rape and sexual slavery is therefore the same. The Chamber's assessment of sexual slavery for both the civilian and female members of the UPC FPLC under the age of 15, therefore, encompasses only the additional element of the exercise of power of ownership. The Court's legal framework accords a special status to sexual violence crimes, crimes against children and the victims thereof. During the drafting process of the Rome Statute, the especially grave nature and consequences of sexual violence crimes, in particular against children, were recognized. The rape and sexual slavery of civilians and of the UPC FPLC members under the age of 15 in the case are indeed very serious crimes. The number of civilian victims of rape in particular is substantial, while the number of female UPC FPLC victims under the age of 15 is lower. Their rapes were systematic, and for the UPC FPLC victims subjected to sexual slavery, their deprivation of liberty lasted longer than for the civilian victims. Victims suffered physical, psychological, psychiatric, and social consequences such as ostracization, stigmatization, and social rejection, both in the immediate and longer term. For example, a 13-year-old victim of rape from Mongwalu suffered injuries which took several months to heal and required surgery years later. She incurred a long-lasting fear which caused her to drop out of school. A psychological expert who testified before the Chamber assessed 2 civilian victims of rape and 1 civilian victim of rape and sexual slavery. She found that they suffer from post-traumatic stress disorder, experience issues with sexuality, and distortions of self-image. Children under the age of 15 who were subjected to sexual violence when they were members of the UPC FPLC similarly suffered physical and psychological consequences, including sexually transmitted diseases and unwanted pregnancies. Mr. Ntaganda's level of intent and participation was substantial as far as the sexual crimes against civilians are concerned, while his degree of intent in relation to the commission of the sexual crimes against child soldiers was lower than for the sexual crimes against civilians. His degree of participation in their commission was significant. The Chamber further identified the following factors in aggravation for the civilian victims: the particular defenselessness of the civilian victims of rape and sexual slavery, and specifically as to rape, the repeated victimization of some of the victims, as well as the particular cruelty of commission in a number of incidents. For the female UPC FPLC victims under the age of 15, the Chamber considered the particular defenselessness of the victims and the repeated nature of the victimization as aggravating factors. In determining the sentence for sexual slavery of both the civilian and female UPC FPLC soldier victims under the age of 15, the Chamber considered only the additional element of exercise of a power of ownership, because the sexual violence they suffered was already considered and reflected in the sentence for rape. Now I turn to crimes against property and civilian objects. As regards pillage, the Chamber found Mr. Ntaganda responsible as an indirect co-perpetrator for the appropriation of items during the first operation in Mongwalu and Sayo by UPC FPLC soldiers, and in Mongwalu also by Hema civilians. He was further convicted for the pillaging by UPC FPLC soldiers in Kobu, Lipri, Bambu, and Jichu, and the context of the second operation. Many civilians were affected by the looting, and they were sometimes left without anything. The Chamber further found Mr. Ntaganda responsible as an indirect co-perpetrator for intentionally directing an attack against protected object, namely the health center in Sayo, in the context of the first operation, especially in times of armed conflict and during ongoing hostilities, when, as a result of the fighting, more persons become injured or wounded. The protection of medical facilities must be respected. Attacking such structures disrupts the ability of medical personnel to care for the sick and wounded. Indeed, when the Sayo Health Center was attacked, 5 patients who were unable to live by themselves were left without medical care. This was considered to be an aggravating factor by the Chamber. Mr. Ntaganda was also convicted as an indirect co-perpetrator for the destroying by shelling or burning of houses and buildings in or around 8 towns and villages. This crime was therefore committed on a significant scale and with a considerable geographical spread of the criminal conduct. Destroying one's house deprives the victim of a private place and shelter and a sense of security. Now I turn to the next crimes. The Chamber found Mr. Ntaganda responsible as an indirect co-perpetrator for forcible transfer of population in Mongwalu in the context of the first operation, and in Lipri, Tsili, Kobu, and Bambu in the context of the second operation. It also found Mr. Ntaganda responsible as an indirect co-perpetrator for ordering the displacement of the civilian population in these same locations. Forcible transfer of population as a crime against humanity is in abstracto more serious than ordering the displacement of the civilian population as a war crime, as the latter is committed by ordering alone. In the circumstances of the present case, the coercive acts which caused the transfer of the population in the course of the first and second operation are the same acts on the basis of which Mr. Ntaganda was convicted for the crimes charged under counts 1 to 5, 7, 8, 11, and 17 to 18. In determining the sentence for the crime against humanity charged under count 12, the Chamber therefore only considered the additional element of forcible transfer of one or more persons from the area in which they were lawfully present without grounds permitted under international law. The number of persons affected by forcible transfer was significant, and part of those who fled into the bush had to endure harsh living conditions. Moreover, a great number of those who fled Mongvalu during the first operation arrived in localities from which individuals were later again forcibly transferred. Mr. Ntaganda's degree of culpability was substantial in relation to the aforementioned crimes committed during both the first and the second operation, while in the view of the Chamber, his degree of participation was even higher during the first operation due to his presence in the field and his direct order to this place. Having considered all other crimes committed against the Lendu, I now turn to the remaining crime that specifically targeted the Lendu as a group, which is persecution as a crime against humanity. The Chamber found Mr. Ntaganda responsible for persecution as a direct perpetrator by killing Abe Bvanalonga in Mongvalu in the context of the first operation. It also found him responsible for this crime as an indirect co-perpetrator during the first and second operation in, respectively, 4 and 9 towns and villages. Persecution is one of the most serious crimes against humanity, as it amounts to denial of fundamental rights of one or more persons by virtue of the fact that they belong to a particular group or collectivity. In the circumstances of the present case, while acknowledging the gravity of the crime, the Chamber notes that the same conduct underlies Mr. Ntaganda's conviction for persecution and his conviction for the crimes committed against the Lendu in the context of the first and second operation, that is counts 1 to 5, 7 to 8, 11 to 13, and 17 to 18. What differentiates the aforementioned crimes from persecution is the additional legal element of discriminatory intent required to be proven for persecution. However, in this respect, as far as commission as an indirect co-perpetrator is concerned, the conduct of the underlying crimes was pursuant to a common plan and organizational policy that also contained a discriminatory element against the Lendu. As far as commission as a direct perpetrator is concerned, the Chamber already took into account that Mr. Ntaganda's murder of the Abe had a discriminatory dimension. In these circumstances, the Chamber considers that the sentence imposed on Mr. Ntaganda for the crime of persecution, both as direct perpetrator and as an indirect co-perpetrator, should not be higher than the highest sentence imposed on him for the underlying crimes amounting to persecution. Having addressed the crimes committed against the Lendu, I now turn to the remaining crimes, those committed against children under the age of 15 who were recruited into the UPC FPLC. I recall that I already addressed the sexual violence crimes committed against some of the children in this armed group. The Chamber found Mr. Ntaganda responsible as an indirect co-perpetrator for conscripting and enlisting children under the age of 15 years into the UPC FPLC between on or about 6 August 2002 and 31st December 2003, and for using children to participate actively in hostilities between on or about 6 August 2002 and 30th May 2003. Children under 15 were used in the first operation and in the May 2003 assault on Bunia as bodyguards for UPC FPLC soldiers and commanders, including for Mr. Ntaganda himself and for UPC President Thomas Lubanga, and to gather information about the opposing forces and MONUC personnel. Enlistment, conscription, and use of children under 15 to participate actively in hostilities are quite serious crimes. association with an armed group can have a significant impact on children. The living conditions for the child recruits in the training camps was harsh. They were subjected to threats, including to their life, monitoring of movement, and severe punishments, including beatings and executions, sometimes without apparent reason. A former child soldier testified that her future had been compromised and her life had been ruined by the fact that her studies were interrupted. Furthermore, using them in hostilities places them at additional risk. Some of those who engaged in combat were made to kill people, and some got shot at, were injured, or died on the battlefield. While Mr. Ntaganda's degree of intent in relation to the commission of these crimes were lower than in relation to the commission of crimes against the Lendo, his degree of participation in their commission was significant. Among other things, Mr. Ntaganda was throughout the relevant period personally and actively involved in the UPC-FPLC's recruitment and training process. Their training fell under his responsibility, and he regularly paid visits to the various training camps. Also, Mr. Ntaganda's personal escort also included at least 3 individuals under the age of 15 who, for example, guarded his residence and compound and participated in combat operations with him. The Chamber further identified the particularly harsh treatment of the recruits and the fact that some of the victims were particularly defenseless as aggravating factors. That completes the summary of the Chamber's considerations about the gravity of the crimes Mr. Ntaganda was convicted of and his culpability therefor. I now turn to Mr. Ntaganda's individual circumstances. The Chamber considered a number of potentially mitigating circumstances in this case. The defense submitted that there were very powerful mitigating factors, whereas the prosecution and legal representatives of victims submitted that there were none warranting any reduction in sentence. In fact, some of the factors submitted by the defense were actually referred to by the prosecution and one of the legal representatives of victims as factors that heighten the need for a high sentence. The prosecution referred in this regard to Mr. Ntaganda's age, his position and experience, and his history with the Rwandan genocide. The legal representative of the victims of the attacks similarly submitted that Mr. Ntaganda's intelligence and military education should be considered as an aggravating factor. First, the Chamber considered Mr. Ntaganda's age, position, and military training and experience. It rejected the defense suggestion that Mr. Ntaganda was very young in assuming his responsibilities within the UPC-FPLC. It considered his age at the relevant time to be neither an aggravating nor mitigating factor. Other matters in relation to Mr. Ntaganda's position at the time and military training and experience were considered by the Chamber in assessing his culpability. Second, the Chamber considered Mr. Ntaganda's personal experience during the Rwanda genocide. Although the Chamber does not doubt the traumatic impact on Mr. Ntaganda of having lived through the Rwandan genocide, and indeed acknowledged that in its judgment it considered that the alleged protection of one group through acts aimed at the destruction and disintegration of another could not, under any circumstance, constitute a matter of mitigation. It therefore decided not to give this factor any weight. Third, the Chamber considered measures allegedly taken by Mr. Ntaganda to save the lives of enemy combatants and protect civilians. However, the Chamber did not consider the alleged instances of Mr. Ntaganda's conduct in this regard to be established on a balance of probabilities and therefore did not give this matter any weight in mitigation. Fourth, the Chamber considered Mr. Ntaganda's alleged contribution to peace, reconciliation and security in 2004 in Ituri, and after examining all the relevant material, including evidence led during the sentencing hearing, the Chamber did not find a genuine and concrete contribution to peace and reconciliation or demobilization and disarmament to be established on the part of Mr. Ntaganda on a balance of probabilities. It therefore did not give this matter weight in mitigation. Fifth, the Chamber considered matters related to Mr. Ntaganda's behavior towards and cooperation with the court. These were Mr. Ntaganda's voluntary surrender, his behavior during trial, and behavior in detention. However, the Chamber noted the significant delay of 5 years of Mr. Ntaganda's surrender, which for the Chamber reduced the value of its mitigating impact, and noted that the behavior during trial was not exceptional. Neither factor was therefore afforded weight in mitigation. Weighing the conduct in detention with the overall gravity of the crimes and aggravating circumstances established of the crimes, the Chamber considered the weight accorded to be too limited to impact on the individual and overall sentences. Sixth, the Chamber considered Mr. Ntaganda's actions and statements in relation to the victims. While noting with appreciation the expressions of compassion made by Mr. Ntaganda on 2 occasions during the trial, the Chamber considered them to be very general, directed at the victims of all ethnic groups who suffered during the conflict in the DRC between 2002 and 2003, and continuing rather than specifically directed at the victims of his own crimes. Overall, the Chamber concluded that the expressions of compassion were not sufficient to constitute a mitigating circumstance. Finally, the Chamber considered Mr. Ntaganda's family circumstances and the conditions of his detention. The Chamber took account of the defense submissions on the impact of restrictions on Mr. Ntaganda's contacts on him and his family, compounded by the remoteness of his place of detention. However, the Chamber also noted that the restrictions were imposed on Mr. Ntaganda because of his own actions, and that the restrictions were being periodically reviewed, including as to their continuing proportionality to and impact on Mr. Ntaganda's family and private life. These matters were therefore not given weight in mitigation by the Chamber. In addition to Mr. Ntaganda's individual circumstances that were analyzed as potential mitigating factors, the Chamber also considered those personal circumstances that, according to the prosecution and legal representatives of victims, must be seen as general aggravating factors. According to the prosecution, Mr. Ntaganda engaged in misconduct at the ICC detention center. The prosecution submitted that his attempts to obstruct the investigation and/or prosecution of the charges in this case are aggravating factors that warrant a higher sentence. The legal representatives of the former child soldiers similarly argued that the Chamber ought to take the alleged witness interference into account for the purpose of sentencing. During the trial proceedings, the Chamber imposed restrictions on Mr. Ntaganda's communication because there were reasonable grounds to believe that he engaged in conduct that warranted their imposition, pursuant to Regulation 101 sub 2 of the regulations of the Court, including reasonable grounds to believe that Mr. Ntaganda intended or attempted to engage in witness interference. However, since it did so, the Chamber was not presented with further information that would warrant making such findings to a different standard. This is relevant as any aggravating circumstances have to be proven beyond reasonable doubt. According to the prosecution, the Chamber should now enter specific findings beyond reasonable doubt regarding Mr. Ntaganda's alleged witness interference. However, given that the information on which the prosecution requested the Chamber to make such findings is neither in evidence nor tested through the regular process applicable to trial proceedings, the Chamber could not make findings to this standard. Consequently, the allegations about witness interference were not taken into account as aggravating circumstances. Now I reach the pronouncement of the actual sentences. In addition to imprisonment, a Chamber may impose a fine or forfeiture of proceeds. In the circumstances of the case, taking into consideration the nature and gravity of the crimes, as well as Mr. Ntaganda's insolvency, the Chamber does not consider it appropriate to do so. On the basis of its overall assessment, including of Mr. Ntaganda's individual circumstances, as I referred to earlier, the Chamber considers the following sentences to appropriately reflect the gravity of the crimes, Mr. Ntaganda's culpability, and any aggravating circumstances the Chamber found for the specific crimes. I will read these out in order of severity of the sentence of imprisonment. Mr. Ntaganda, please rise. So those sentences are following. For ordering the displacement of the civilian population as a war crime, 8 years. For forcible transfer of the civilian population as a crime against humanity, 10 years. For intentional directing attacks against protected objects as a war crime, 10 years. For pillage as a war crime, 12 years. For sexual slavery of civilians as a crime against humanity and as a war crime, 12 years. For sexual slavery of children under the age of 15 incorporated into the UPC-FPLC, 14 years. For intentionally directing attacks against civilians as a war crime, 14 years. For destroying the adversary's property as a war crime, 15 years. For rape of children under the age of 15, incorporated into the UPC-FPLC as a war crime, 17 years. For conscripting and enlisting children under the age of 15 years into an armed group and using them to participate actively in hostilities as a war crime, 18 years. For rape of civilians as a crime against humanity and as a war crime, 28 years. For murder and attempted murder as a crime against humanity and as a war crime, 30 years. For persecution as a crime against humanity, 30 years of imprisonment. Mr. Ntaganda, you may sit down for now. And after these individual sentences, the Chamber must also pronounce a joint sentence, specifying the total period of imprisonment. Article 78, paragraph 3 of the statute specifies that the total period of imprisonment shall be no less than the highest individual sentence pronounced. Furthermore, in conformity with Article 77, unless a sentence of life imprisonment is imposed, the total period of imprisonment shall not exceed 30 years of imprisonment. As I mentioned earlier, the sentence for the crime against the humanity of persecution combines Mr. Ntaganda's culpability and the aggravating circumstances for the underlying crimes committed against the Lendu. However, in order to properly account for the multiplicity of crimes and his overall culpability, the total sentence to be imposed on Mr. Ntaganda must also reflect his conviction for the additional crimes committed vis-à-vis children under the age of 15 who were recruited into the UPC FPLC. As the Chamber determined the highest individual sentence to be 30 years of imprisonment, and since the maximum imprisonment for a specified number of years is also 30 years, the Chamber can only impose 30 years or life imprisonment as the overall joint sentence. Life imprisonment is permissible as a penalty under the statute when justified by the extreme gravity of the crime and the individual circumstances of the convicted person. The Chamber has taken note of the wish of the victims, represented by the legal representative of victims of the attacks, for a joint sentence of life imprisonment to be imposed. However, having regard to its conclusion per crime, noting the overlap in conduct between part of these crimes, and on the basis of all other considerations relevant to this case, notwithstanding the fact that there are no mitigating circumstances to be afforded anyway, the Chamber found that the crimes for which Mr. Ntaganda has been convicted, despite their gravity and his degree of culpability, nevertheless do not warrant a sentence of life imprisonment. Accordingly, and now Mr. Ntaganda, please rise again. Mr. Ntaganda, in the particular circumstances of this case, as a result of the highest individual sentence and the statutorily mandated maximum specified term of imprisonment for the joint sentence being the same, no further discretion is given to the Chamber in the determination of the overall joint sentence. The overall sentence imposed on you shall therefore be 30 years of imprisonment. You may sit down now. Pursuant to Article 78, sub 2 of the statute, the time you have spent, Mr. Ntaganda, in detention in accordance with an order of this court, namely since 22nd March 2013, following your surrender to the court, shall be deducted from your sentence. The Chamber has already issued an order in relation to reparations and received submissions and observations from the relevant actors. Further matters related to the reparations procedure will be addressed by the Chamber in due course. The full sentencing judgment will be notified upon the closing of this hearing. And also I would like to guide you, Mr. Ntaganda, that you are entitled to appeal our decision on your sentence within 30 days. This concludes the hearing. The court stands adjourned.
All rise.